Good morning, this is your Kelso Report for Wednesday, April 24th. I'm your host, Clark Kelso. We begin today with a U.S. Supreme Court decision involving the question of whether a state conviction for social sharing of a small amount of marijuana is an aggravated felony for immigration purposes. We then turn to a California Supreme Court decision involving a defendant's waiver of an objection to payment of a small jail booking fee, and a decision involving the definition of an accessory under state law. Our final case from the California Court of Appeal involves a waiver of jury trial in the context of a mentally disordered offender proceeding. In our first case, Moncrief v. Holder, we once again see the Supreme Court interpreting federal immigration law in the context of varying state criminal laws. The issue this time involves interpreting the phrase aggravated felony. In particular, the Immigration and Nationalization Act provides that a non-citizen who has been convicted of an aggravated felony may be deported from this country. The Act also prohibits the Attorney General from granting discretionary relief from removal to an aggravated felon, no matter how compelling his or her case. Among the crimes that are classified as aggravated felonies, and thus lead to these harsh consequences, are illicit drug trafficking offenses. The issue before the court in Moncrief was whether an illicit drug trafficking offense includes a state criminal statute that extends to the social sharing of a small amount of marijuana. In a 7-2 opinion that shows just how far our society has moved away from the so-called war on drugs from the Nixon era, the court held that a state criminal statute which criminalizes the social sharing of a small amount of marijuana, sharing without remuneration, does not constitute a drug trafficking offense and is therefore not an aggravated felony. So you non-citizens who worry about engaging in criminal conduct that may make you deportable without recourse, light up and enjoy. Our next case involves criminal booking, jail booking fees, and a question of waiver of those fees from the California Supreme Court. Our criminal justice system, as you know, places a high value upon due process and upon making sure that a defendant's rights are fully protected. But there are limits to how far the law will protect a defendant who does not protect himself. In People v. McCullough, the defendant pleaded no contest to being a convicted felon in possession of a firearm and admitted a prior prison term allegation. The court imposed the stipulated state prison sentence of 4 years and also ordered the defendant to pay a $270 jail booking fee. The defendant failed to object to imposition of that fee at the trial court level, and, on appeal, claims it was error to impose the fee because the court never determined, as required by the applicable statute, that the defendant was able to pay it. The Supreme Court rejected the defendant's attempt to raise this issue on appeal, holding unanimously that a defendant who fails to object that the evidence was insufficient to support a finding of his ability to pay a booking fee when the court imposed it has forfeited his right to challenge the fee on appeal. As the court explained, the right to avoid paying a relatively modest booking fee is not so central to the proper administration of criminal justice so that a defendant can raise the issue for the first time on appeal without having objected at the proper time. Next, the California Supreme Court addressed the law of accessories. According to Section 32 of the Penal Code, an accessory is a person, quote, who, after a felony has been committed, harbors, conceals, or aids a principal in such felony with the intent that said principal may avoid or escape from arrest, trial, conviction, or punishment, having knowledge that said principal has committed such felony or has been charged with such felony or convicted thereof, close quote. In People v. Knuckles, the Supreme Court addressed the question whether a person who intentionally aids a parolee in absconding from parole supervision qualifies as an accessory to the crime for which the parolee had originally been sentenced to prison. The court held that such a person was indeed an accessory. The defendant argued that there was not a sufficient nexus between the original crime and aiding a parolee in absconding. But the court disagreed, noting that so long as the defendant intentionally helped a parolee avoid some aspect of his punishment for his felony conviction, that established the sufficient nexus between her aid and the original felony. Section 32, after all, expressly refers to aiding a felon avoid punishment. So, although it may be a little surprising, when you help a felon abscond from parole, you have just become an accessory to the underlying felony. Our last case also involves a waiver of rights at the trial court level. And here, because the right being waived is the right to a jury trial, the courts are a lot more careful about ensuring that the waiver is knowing and deliberate. Under California's Mentally Disordered Offender Act, the state can commit a mentally disordered offender to a hospital for treatment as a condition of parole, and can extend the commitment at the end of the parole period if the offender poses a danger to others due to his or her mental disorder. The Act gives the offender a right to a jury trial. In People v. Blackburn, the 6th District addressed the question of whether the offender must personally waive the right to a jury trial, or whether that decision may be made exclusively by counsel. The court rejected both extremes, holding that the Act does not require a personal waiver in all instances, and also does not give counsel exclusive control in all instances. Instead, counsel may waive a jury at the offender's direction or with the offender's consent. But when there is cause to doubt the offender's capacity to make the waiver decision, then counsel can make the decision even over the offender's objection. And to make sure there is a clear record for appeal, the panel held that when the court conducts a bench trial, the record must contain an express waiver and affirmatively establish the validity of that waiver. As you can see, the right to a jury trial is a lot more important than the right of an indigent to avoid paying a nominal booking fee. And that's it for today's Kelso Report. Have a great day in the law.